Please be seated. Next case on the docket is Hendricks versus the State of Florida. Counsel.
Good morning, and may it please the Court. I'm Gray Thomas of Shepherd, White, Thomas, and Katurgis in Jacksonville on behalf of the appellant Ronald Wayne Hendricks. I'd like to reserve 4 minutes for rebuttal. In this appeal, we've raised 4 grounds for reversal, all of which must be reviewed in light of this case being a one-on-one swearing contest in which the allegations giving rise to the prosecution first arose years after the incidents were claimed to have occurred. It's a case in which there were 4 counts that were tried. Mr. Hendricks was convicted of 2, was convicted of a lesser offense on a 3rd count, and was acquitted on a 4th count. It clearly was a close case, and it presents issues of evidence, criminal procedure, and constitutional law. I'd like to initially start off with what we have set forth as issue 1, which is the exclusion of character evidence offered by Mr. Hendricks. The character evidence that he offered that the state challenged was evidence of his reputation for sexual morality. This is a case in which there is only one decision, specifically in Florida, to use that term. That is the Alvello case from the 5th District, which when you parse the language, as Professor Earhart has done, and as I'm sure we all have, that the case ultimately did not involve reputation evidence, but rather a type of evidence that is not permitted as character evidence in the form of individual opinion.
And how does the evidence in that case differ from here?
Well, the evidence in that case, and it's a short opinion, so the Alvello decision doesn't articulate with great specificity what exactly was to be offered. But when you read the opinion, they're talking about offering, the defense offering specific acts. I didn't do this, I didn't commit this act of sexual misconduct toward this person. I haven't abused my child. I haven't abused that person. That's specific act conduct. That's different than reputation conduct, and reputation conduct is admissible under 90.4051 when it is otherwise admissible. And in a case like this, sexual morality in a sex offense case is evidence of a pertinent character trait that's admissible under 90.4041A.
But counsel, wouldn't the testimony that the appellant had a good reputation for truth and veracity have carried more weight with the jury than testimony that he seemed not to be a sexual deviant? In other words, since the character testimony bearing directly on the appellant's credibility was omitted, isn't the exclusion of the testimony regarding sexual normalcy harmless?
Not a bit. In every case, evidence relating to the truthfulness of any witness is always relevant. But in a case like this, Mr. Hendricks did indeed testify in his own defense at trial. So the evidence of his reputation for truth and veracity was properly admitted. However, this case also involved another character trait that was pertinent to the charges themselves, and that's the evidence of his reputation for sexual normalcy, sexual morality is the way it was offered.
But counsel, shouldn't that reputation evidence be drawn from a sufficiently broad cross-section of the community, and was that standard met here?
Absolutely. As a matter of fact, when the 2 witnesses were inquired of by defense counsel at trial, the predicate questions were laid. And with respect to Mr. Hendricks' former wife, Ms. Nipper, the question that was, as it was articulated, was, have you known hundreds and hundreds of people who've known him and know his reputation from hundreds and hundreds of people who you've known over the course of his life? With respect to his daughter, Ms. Rhodes, the question was many, many people. So you had, and the state never tried to voir dire on that point to undermine it at all, and so that is the state of the evidence, that you had a very broad base. In fact, there are the cases in the 4th District that we've cited in our briefs that are a little bit in conflict, one in which reputation based on 3 or 4 people was found not to be a broad enough base, and in another case, reputation based on knowledge from 4 or 5 people was found to be sufficient.
Counsel, is the reliability of reputation testimony an issue of admissibility?
Of course it is. It's an issue of admissibility both under the Florida Evidence Code and also under the constitutional right to present a defense in a criminal case. And so that's why this issue has aspects of a constitutional dimension, not merely a matter of compliance with the Evidence Code.
Counsel, the 5th District observed in the Alvelo case, I think that's how you pronounce it anyway, that unlike a person's reputation for honesty, one's reputation for sexual normalcy is not necessarily something that would be generally known in the community, since it's such a private matter. How do you address that issue?
Well, I think you address it as first of all, as a practical matter. People do get reputations for being sexually moral or sexually immoral. People do get reputations for things that relate to what is ordinarily private conduct. That's an area where people may not know a lot of specific instances, but people get reputations. We've heard about reputations since high school. Also, because of that, because Florida allows this evidence of character to be presented by reputation, as a number of the other states that have been addressed in the briefs, that's an impressionistic standard. But because it's impressionistic, that is why there's a requirement that it be broad-based, based on many, many people, hundreds and hundreds of people, which is what we have in this case.
Counsel, moving to your second issue, that is whether the trial court fundamentally erred in failing to follow the procedure for allowing juror questions and by posting its own questions to the witness.
Yes, sir.
Couldn't defense counsel have objected in a sidebar conference with the court?
Your Honor, what transpired is at the commencement of the trial, this court told the jurors that it's going to let them take notes, and part of the reason for that is because they may have some questions they want to submit later, and the court even made reference to considering those questions with or without consulting counsel. Then, at page 325 of the transcript, any juror have a question for the witness? The bailiff, right here. The court, why did you not tell Ms. Sapp about the child grabbing her privates in the shower? Witness, and the witness in this case is Mr. Hendricks, testifying in his own defense, and he gives an answer. The question was asked before counsel had an opportunity to object. This also relates to the issue 4, where the issue is opportunity to.
It was counsel's duty to preserve the record, at least by requesting that the written juror questions be filed.
I'm sorry, I couldn't hear, Your Honor.
Wasn't it the defense's duty to preserve the record, at least by requesting that the written juror questions be filed?
And so did the court. Counsel, let's address Rule 3.410 and your reading of the per se nature of the error in not offering counsel the opportunity to respond. The states filed supplemental authority in 2 of this court's cases, in Page and Saylor, that discuss the Supreme Court's Thomas case, where at least what the state is saying is that in Thomas it brought back in the requirement to preserve this error. Would you address the supplemental authority in Thomas, please?
Yes, sir. And we also filed a supplemental authority on issue 1 yesterday, and Mr. Kennett and I talked about it since we were both filing late supplemental authorities. But yes, I don't believe that the preservation issue has ever been simply not required. But what we have in this case is a circumstance that is really more akin to what happened in the second district case in Greenfield, where you must have an opportunity. And in this case, the court did not give counsel an opportunity. The court said at page 436 of the transcript, "Bring me the question if you would. May we see the transcript of the testimony of Ms. McClure regarding the third charge relating to the allegation about Mr. Hendricks placing his penis on Ms. McClure and ejaculating? I think the answer is no. Rely on your memory. Will you waive Mr. Green's presence?" Mr. Green is co-counsel. Mr. Ellis, "Yes, Your Honor." The court, "All right, you all take your seats." Ask them to just come out and stand right here, whereupon the jury was brought into the courtroom and told no. And not only did was counsel at that point not given the opportunity to make the proper objection, but the court also then proceeded to affirmatively misinform the jury by failing to let the jury know that the possibility existed for a readback of that testimony. And so you've got a double whammy that occurred with respect to that.
Counsel, we do agree that we must follow a Page and Saylor.
Yes, but I don't believe that they are binding under this circumstance, because Page and Saylor do not allow a court to proceed without providing counsel the opportunity to make an objection.
Yeah, but if mere presence of counsel isn't enough to satisfy Rule 3.410, are there specific words a trial judge must say to ensure that the defendant has had a full opportunity to present arguments concerning the jury's request?
The only thing that a trial judge has to do is say, "Counsel, what do you think?"
Counsel, is that really required? Because the rule requires notice. And in this case, defense counsel was present, defense counsel heard the question from the jury, and remained silent. Isn't that factually distinguishable?
Not where the trial judge proceeds to steamroll over counsel and say, "You want to waive your co-counsel's presence," and goes no further and then says, "Bring the jury in." And I would like to reserve the balance of my time, if that's okay. Thank you.
May it please the Court, Michael Kennett for the State of Florida.
Counsel, while it's fresh on my mind, address the issue that the appellant's counsel last addressed, and that is the impact of the Page and Saylor cases that you filed as supplemental authority.
In order for this Court to award relief on Issue 4, it would have to recede from Page and Saylor. There's just no way around that. And the language from Page is quite interesting. It talks about the calculated silence of a defense counsel who is present. This Court said, "Trial judges must beware this pitfall or suffer a new trial even upon defense's calculated silence." This Court was correct to note in Page that the Florida Supreme Court recognized in Thomas that there is a preservation requirement. It would be the ultimate example of sandbagging if a defense counsel can just sit there on his hands, do absolutely nothing, wait to see if the verdict is favorable. If it is, hey, nothing else to do. If it's not, then raise it as an issue on appeal as per se. And in this case, per se fundamental error. That is not what the Florida Supreme Court contemplated in Thomas, and that is exactly the problem that this Court identified in Page. So in order to award relief in this case on Issue 4, this Court would have to recede from Page. And
now, in Page, refresh my memory if you would, was there any notice at all given to counsel? They were present at the time, and is that, because as I understand appellant's argument here, the case before us, there was no notice at all about, what do you think?
well, that's interesting because we have a cold record, but the appellant certainly read that interplay in one way, but it could have been read another way. It's important to note that the trial court here said, "I think the answer is no." That could have been an invitation to defense counsel. What do you think? You know, I think the answer is no. I'm going to give him a read back and tell him to rely upon their recollection. We don't know what the tone of voice was of the trial court. It might have been, well, I think this is the answer, but that ambiguity goes to the state's favor because the appellant has the burden to demonstrate fundamental error. He has to show that the trial court's actions so corrupted the proceedings that he's entitled to a new trial. And he just can't do that with this record. So it's the state's position that I think was an open invitation. And there's another question. Do you waive the presence of co-counsel? So there was an actual opportunity where the trial court reached out to the defense counsel and asked him a question. If he had a problem with the trial court's approach to the juror's inquiry, that was the appropriate time to voice that.
Well, counsel, even under the Supreme Court precedent and this court's precedent, does the court actually have to use the words, do you object, or something akin to that, or is it simply sufficient for the court to state what the jury's question was and provide notice to counsel who is then present?
That would be what the rule seems to contemplate, because the rule just says notice. And notice is typically, you're there and you have the opportunity to, you have an obligation to do something, to say something. You're present and you can voice an objection. You can say, Judge, I think this, or Judge, I think that. So the rule seems to contemplate simple notice, simple presence. Now, there are some cases from the Florida Supreme Court in the 70s and the 80s that seem to suggest otherwise, but Thomas closed the door on that by saying there is a preservation requirement, and Page follows up on that.
But doesn't Thomas, in Thomas, didn't the trial judge ask counsel if they had an objection to the process?
There was a waiver in Thomas, and in this court's decision in Thomas, the focus was on the waiver. But it's important to note that in Page, this court recognized that when the Florida Supreme Court addressed Thomas, they didn't rule exclusively on the presence of a waiver. I'll read from Page. The only issue present and ruled upon by this court was affirmative waiver. See the first DCA's decision in Thomas. However,
isn't it correct that in the Thomas case, the defense counsel was present and they received notice, and that's factually distinguishable from the Bradley and Ivory opinions previously from the Supreme Court?
Yes, this isn't a case where the judge ex parte addressed the concerns from the trial, from the jury, and then the defense counsel and the prosecutor found out about it afterward. This isn't that type of case. This is defense counsel standing right there. The judge says, I think the answer is no, and he sits silent. And we can't allow sandbagging in this kind of situation. It defeats the purpose of the contemporaneous objection rule. Now, turning to issue 1. In order to be admissible, character evidence must relate to a pertinent trait. It must be probative, and it must be reliable. Sexual normalcy, reputation evidence simply is not pertinent in a capital sexual battery case. It's also not probative. Unlike truthfulness or peacefulness, sexual liaisons don't take place in public view. The community...
In reference to your argument, counsel, you're correct. You argue that the community would not have an opportunity to know whether an appellant was a child molester because acts of child molestation are usually done in secret. Isn't that a matter of weight rather than admissibility?
No, sir. It's not, because all sexual, it's a crime. Even if it's two consenting adults, it's still a crime to engage in sexual intercourse in public. So the community will never have the opportunity to observe whether there is sexual normalcy for a particular individual, because they're never going to see or observe that individual engaging in sexual intercourse, whether it's with an adult or a child. It isn't like truthfulness or peacefulness, where the community really does get the opportunity, just in daily interactions, simple things like, hey, let's do lunch someday. Does the person really mean that? Is that the kind of person who just says that? And that's a minor example, but there are daily interactions that the community has with an individual. Also, the community will talk about that, so that the community opinion becomes trustworthy and reliable in a way that a personal opinion is not. And in this case, the testimony, the proffered testimony of the ex-wife was nothing but a personal opinion. She is too narrow a slice of the community to establish what the community's reputation or what the community's opinion was of the appellant's reputation for sexual proclivity. The daughter, that was just a backdoor way to try to get the absence of specific instances. I'll give you an example. Certainly, former President Bill Clinton has a reputation for infidelity. The community has that impression of him. You wouldn't need to call his daughter in order to establish that. You would call someone from the community. There's no need in this case to call the daughter except for to backdoor the lack of specific instances. and that simply is inadmissible. So it's not reliable, and it's something that the community doesn't, it's apples and oranges, number one.
Your point is, one of your points is that even if an expert was hired to do a survey of the community and came in with 10,000 responses, that the nature of what they're surveying, that is someone's sexual morality, is so essentially private that it by the nature of that conduct, you could never have an accurate community portrayal of that part of somebody's character.
That's correct, sir. And that's a conclusion that the Washington Court of Appeals came to in the Spencer case, which is cited in the state's brief, that reputations concerning sexual conduct are more likely to be based upon speculation rather than on observed conduct. And an excellent example would be Catholic priests. Certainly they would have a reputation for celibacy, but that is not an accurate indication of whether or not they would be a pedophile. And there are, unfortunately, plenty of cases where Catholic priests engage in pedophilic acts.
Counsel, you argue alternatively that even if the type of reputation evidence Hendricks sought to admit were generally admissible, his proffer was insufficient. What testimony should he have included to make the proffer sufficient?
Okay. Have you ever heard anyone in the community discuss your husband or your ex-husband's reputation for sexual behavior? Have you ever heard anyone in the community discuss your father's reputation for sexual behavior? Those questions were never proffered in this case. It was just, well, here's what she'll say. I'm not going to talk about anything specific. I'm not going to talk about a personal opinion. I'll just have the witness testify to sexual behavior. But it's presumed that it's a point of common discussion in the community. But there's no foundation for that. Moving on to issue 2. The appellant, the state essentially concedes that the trial court did not strictly follow the rule of criminal procedure that applies to questions from jurors. But the appellant does not cite anything objectionable about the context or the substance of those questions. If the trial court had followed the procedure, what objection would the defense have made to the questions asked by the judge? The judge didn't ask for hearsay. He didn't ask for a personal opinion. He didn't ask for information that was irrelevant. The questions asked by the court to the appellant were not objectionable based upon their substance. What the appellant is trying to say is that there's a per se rule that applies to the procedure applicable to juror questions, but there's no precedent for that. And it makes no sense to have a per se rule for a technical violation when the appellant can't demonstrate what about that particular question was objectionable.
Do you agree that if the questions concerning the counselor and the shower incident came from the judge rather than the juror, the judge abandoned his neutral role?
If they came from the judge?
That's correct.
Well, first I'll say it's unclear whether they came from the jurors.
Assuming they did for purposes of argument.
Not necessarily, sir. And the reason why is because the appellant repeatedly gave evasive answers. He kept saying over and over again, I don't know. I don't know about that. I don't know about this. I don't know. And so it wasn't as if the trial court said, well, do you expect a jury to believe your cockamamie answer? There were no colorful words like that. It was just simply to the point, trying to get the appellant to clarify and actually answer the question. He kept trying to dodge the question and evade the question. So there was no language that was over the top, no argumentative language, nothing along the lines of, do you expect us to believe X, Y, or Z? Just, why didn't you do this? Okay, well, why didn't you do that? They may have been damaging somewhat, but they didn't reflect a trial court abandoning his role as a neutral and detached officer of the court, or as a judge. So it's also important to know that if those questions did come from a juror, it doesn't matter how damaging a question is. A judge does not abandon his role of impartiality if he asks a question that comes from the juror, so long as the juror question is admissible, is relevant, is probative. So if the state fails to prove a particular element of an offense, and the question comes from the juror, there's nothing wrong with the trial court asking that question, even though it will help prove the state's case because the question came from the juror. In this case, we don't know where the question came from. Why? Because the defense did not object. That's why we have a contemporaneous objection rule. If they had objected, that would have afforded the trial court the opportunity to address the purported error right then and there. And that is one of the purposes of the contemporaneous objection rule. Don't let this purported error fester for exploitation on appeal. Give the trial court the opportunity at the earliest moment to address the possible error. Don't sandbag. And so in this case, there are repeated instances where issues 2, 3, and 4 were not preserved below. And on all of those issues, the appellant cannot demonstrate fundamental error that corrupted the integrity of the proceedings. If there being no further questions, the State asks that the Court affirm.
I think, first of all, there is nothing in this record as it relates to the State's argument on issue 4 that suggests that counsel engaged in calculated silence. If you read that record, there's nothing calculated about what defense counsel did. The court simply said, here's what the jury has asked. The answer is no. Will you waive your co-counsel's presence because he's not here yet, and proceeded to bring in the jury and deal with the jury that way. If you can't deal with this on the basis of this record, then we're going to be back here on a 3850 down the road. Page and Saylor also, while they stress the importance of a contemporaneous objection, and I recognize that importance, they don't obviate the need for there to be an opportunity to be heard. As a matter of fact, the Mills case from the Supreme Court in 1993 stressed the issue of opportunity to be heard, and what kind of meaningful notice can you have if notice does not include the opportunity to be heard. That's a fundamental point of due process of law. With respect to the issue of
But
yes, sir.
I'm struggling with Page and Saylor. They don't seem to say, I mean, you can even read into Thomas the need to be heard, but Page, for example, just talks about the fact that defense counsel and the defendant were present in the courtroom and didn't make a contemporaneous objection. We affirm. They really don't discuss whether, or the importance, or whether or not the trial judge was required to do something. So given Page, why isn't the State correct that in order for us to reverse on this point, we would have to recede from Page?
Well, I don't think, while Page discusses what transpired in that case, it discusses it and shows that indeed there was interaction. The court indeed engaged defense counsel, and defense counsel not only had an opportunity, but utilized the opportunity. If you read the opinion itself, and there's nothing about Page or Saylor that obviates the issue of an opportunity to be heard. Is an opportunity to be heard now going to be reduced to, you can get an email from the court that says the jury has a question, you're going to give the answer as no, and you're going to tell it to them before waiting for defense counsel to get to the courthouse?
Well, counsel, what kind of
Are there specific words a trial judge must say to ensure that the defendant has had a full opportunity to represent argument and support?
The only thing that a court needs to do is to give counsel the opportunity, and usually that is signaled when especially when you're looking at a cold record, by saying, any objections? What do you think? Should we answer their question? Oh, how about the rule that allows for a readback? Shouldn't we tell the jury about that rule? You've got to say something to trigger the opportunity.
But doesn't the court reading the question from the jury and proposing the court's instruction give precisely that opportunity that the rule requires?
Not when the matter proceeds as the record shows it did proceed. Here's the question. The answer is no. Will you waive counsel's presence? Bring in the jury.
What required defense counsel to remain silent at that moment?
Let me tell you, if it had been me, I wouldn't have been silent. But because I would have tried to interrupt the judge. I would have been rude if it took that. These lawyers didn't do it, but they didn't have a meaningful opportunity. And for opportunity to exist, it has to be meaningful. And here, With all due respect to the learned trial judge, he steamrolled over
So
counsel.
you, counsel, you're saying mere presence of counsel is not enough to satisfy the rule?
Correct. You must give a meaningful opportunity for counsel to be heard. And I see that my time has expired, and I would urge the court to reverse on all 4 grounds. Thank you.